online for anyone who's interested. Okay, well, good evening, everyone. Thank you so much for joining us. My name is Emily Cole, and I'm the Executive Director of OFUPAC, which stands for Ohio Families Unite for Political Action and Change. And I'm really excited to have you all with us tonight. So thank you for joining us. And I'm very excited to have Pastor Hank from UUJO here with me too. So we're going to unpack House Bill 109, the anti-protest bill. And as I mentioned at the end, or even just throughout, feel free to ask questions, but we are going to stop the recording at the end for the question portion. So let's get into it. So the goals for this policy hour, we want to review the current law, work through House Bill 109 and how it affects the law, and talk about what this might mean for individuals, families, organizations, and just communities in general. And then we're going to go through some next steps to mobilize for anyone who is called to action after we talk today. So as I mentioned, I'm Emily Cole. I'm the Executive Director of OFUPAC. OFUPAC is a 501c4 nonprofit, and our mission is to uplift and amplify the voices of impacted families to transform the criminal and civil justice landscape in Ohio within one generation. We like to say that we're about policy, action, and change. And so we're really excited to be here with you tonight, and I would love to turn it over to Pastor Hank to introduce himself.
Hi, everybody. My name is Pastor Hank Osbonsen. I use he, him pronouns. I am the Executive Director of Unitarian Universalist Justice Ohio, which is a 501c3 nonprofit, faith-based nonprofit serving to connect the UU congregations throughout the state of Ohio in various social justice realms. My predecessor, Reverend Joan Van Beesler, began the coalition, the Our Voices Together coalition that's working to organize and fight against the anti-protest legislation that's been making its way through the State House. So I inherited that from her, but very, very happy to be a part of the leadership with this and to partner with Emily and OFUPAC. A little bit more about me specifically is that I am a Christian interloper in the Unitarian Universalist world. So they hired me to be the ED, but I am a member of the United Church of Christ. I'm pursuing ordination in the UCC, graduated from seminary with my MDiv last year, graduating with a Master of Arts in Social Justice in a little bit less than a month. So very, very happy about that. And also serve as a ministry intern at St. John's United Church of Christ in downtown Columbus. So really, really happy that you all are here with us tonight, and that Emily and I can share some information about HB 109 with you.
Okay, so what is House Bill 109? Let's go ahead and get into it. So the Legislative Service Commission, for anyone who's not familiar, they're a nonpartisan body that's affiliated with the State House, and they provide unbiased bill analyses and fiscal analyses and summaries of these pieces of legislation, which is really helpful for people like all of us who want an unfiltered look at what's going on at the State House. And so they describe House Bill 109 as a piece of legislation regarding criminal penalties. So it's to increase penalties for certain assault, vandalism, and riot offenses, to allow peace officers to bring civil suits against persons participating in a riot, and to prohibit bias-motivated intimidation of first responders. This is their summary of this bill. The co-sponsors who introduced this bill in the Ohio House are the House Assistant Majority Whip, Cindy Abrams. She is from House District 29, which is part of Hamilton County. And her co-sponsor is Representative Sarah Carruthers from House District 44, which is in Butler County. One thing to note is that Representative Abrams is a former police officer in Cincinnati. So when these bills get introduced, where this one is at currently is it's actually already passed through the House and was voted out of the House and sent over to the Senate, where it was then referred to the Senate Judiciary Committee. And when that happens, usually as a courtesy to the bill sponsors, at minimum, they are allowed to provide sponsor testimony before the committee, which occurred actually on April 5th. And so Representatives Abrams and Carruthers provided, it was a fairly brief sponsor testimony, but we thought it was really important to use their own words here to highlight their testimony. So they frame this bill as the Ohio Law and Order Act, and they say that it supports the men and women of law enforcement. It supports first responders, small businesses and jobs and communities, and supports law-abiding Ohioans. I just want to emphasize anything we're reading in quotes really is their words, and it's from the official text that they submitted to the record. They claim that the bill does not infringe on freedoms of speech and assembly. They claim that today, among the variety of protesters, they're seeing more young people whose focus is hatred towards the police and authority figures. And they say that it is these individuals that are the focus of this bill. They claim this is a common sense bill holding accountable those who break the law. So again, want to emphasize one more time, these are in their words. And another thing that I think Pastor Hank and I forgot to mention, we are not attorneys, but some very brilliant attorneys gave us their input on this, from the ACLU to attorneys who work with us as part of the coalition and within our respective organizations. But anything that's represented is not from an attorney. This is from Pastor Hank and I just trying to break down this bill and bring it down to a level where we feel everyone can understand what's going on and get involved should they feel so inclined. So if you have very technical questions that we feel like are outside of our purview to answer, we will get you an answer, but you'll just have to be a little patient as we take that down and get back to you. So just wanted to say that really quickly before we kept going. So let's go ahead and actually break down what all of this really means, right? Because that's probably the most interesting part. So the ACLU actually provided an update on February 16th about this bill, and this was soon before it passed out of the House. So their read is that it includes extreme penalties, among them the seizing of assets and shutting down organizations for those who engage in constitutionally protected speech. It allows police officers to sue and bankrupt people who make false complaints against them, but provides no detail as to the type of complaint or who decides what is actually false. It creates 3 new felonies and 1 new misdemeanor and enhances 4 current offenses for actions that are already illegal. And in their words, this is an effort to silence, subdue, and criminalize the fundamental right to protest. And actually, so Gary Daniels is the chief lobbyist for the ACLU of Ohio. He gave a great statement on this bill that I would love to share with you because I think it's really important and provides a great summary. So according to Gary, House Bill 109 is by far the worst free speech related bill he's ever seen in the Ohio General Assembly after 23 years working on civil liberties issues with the ACLU of Ohio. This legislation includes extreme penalties, among them the seizing of assets and shutting down organizations who engage in constitutionally protected speech, and also allows police officers to sue individuals who make quote unquote false complaints against them. But the bill provides no detail as to the type of complaint or who decides what is false. At its core, House Bill 109 equates people who engage in civil disobedience at almost all levels with domestic terrorists. This bill is terrible for our democracy, terrible for Ohioans, and is meant to intimidate individuals who exercise their First Amendment rights. This is the ACLU. We strongly urge the members of the House Criminal Justice Committee to vote no on House Bill 109. Fortunately, we all know what happened, and it's now referred to the Senate. And so I'm going to turn it over actually to Pastor Hank to really walk through these key provisions of the bill. And we've got some great examples from some of our team members to break this down a little more. Pastor Hank?
Yeah, so to take you through sort of, we heard what the ACLU said about the penalties either being added to the code or the penalties heightened. So this is a summary of that, and then we're going to take a look at some examples of each of these. So first of all, those folks who are protesting, who block roads, sidewalks, and or other public property can be charged with the first-degree misdemeanor. It's important to note that the qualification here is that if the protesters are involved in what is deemed a riot, and we'll talk a little bit about the legal definition of riot, but again, it's very nebulous as to who decides who calls what when. Second degree felony if you organize or provide other active supports for protests. So this is something that is alarming to folks like me and Emily in particular, and my constituencies and my partners in the faith community, because churches and nonprofit organizations often provide support for folks who are exercising their First Amendment rights. So what does this mean for that? The third provision, organizations, again, that provide active support to protest with loss of property or harm to a police officer. So not only can your organization get in trouble for offering support to the protesters, but police can now make claims against folks providing that support for up to triple the damages that was apparently caused to this first responder. It creates the new offense of riot assault, which makes it between a third to fifth degree felony to engage in a quote unquote riot and recklessly cause physical harm to another person, and creates the new offense of riot vandalism, which makes it between a third to fifth degree felony to engage in a quote unquote riot and recklessly cause physical harm to various kinds of property. I think it's worth noting, probably what all of you are aware of, that this riot wording is really dog whistle language. This bill was written primarily in response to the uproar and demonstrations that happened after the murder of George Floyd, including protests here in Ohio, a large one in Columbus in 2020, that were somehow riots instead of protests. So I think that's important to keep in mind, particularly as we move forward talking about actions that we take and talking about writing testimony in opposition to this legislation. So let's take a look at examples of what might happen and more deeply into the penalties. So the first provision, again, it makes it a first degree misdemeanor for protesters who block roads, sidewalks, or other public and or private property. So that first degree misdemeanor would be punishable by up to 6 months in jail and a $1,000 fine. And under this bill, any group of 5 or more persons blocking a street or other public or private place could be charged with a crime if they are asked to leave but do not. I find it interesting, one, that they would even call 5 people standing on the sidewalk a riot, but apparently that's part of what they intend to be able to do if this bill becomes law. So here are a couple of practical examples. So if it's an act of civil disobedience, a group of 4 or more people block a street, sidewalk, or entrance into city hall or a school and don't leave, the police, principal, other person of authority asks them to leave, they could be charged with a first-degree misdemeanor for being there. And if 4 or more people engage in a sit-in public areas of city hall, so indoors of the state house in a university, they could also be charged with the first-degree misdemeanor if they're there and are asked to leave and don't. And this, again, I'm always struck by what nonsense this seems every time I look at it and think about it, because we think of, I have visions in my head from textbooks, from movies, from newsreels, and from personal experience of sit-ins being what I consider to be quintessentially American free speech. That is part of the way folks make change. So it's just egregious, and buckle your seatbelts because we're going to keep on going here. Second provision, second-degree felony for individuals who organize or provide other active support for protests. So this would be a new section in the law that if an individual or group helps to fund, organize, and that includes calling people to gather together, which I actually did yesterday, calling on folks to come downtown today to rally in support of fair districts, or we actively assist in funding, transportation, training. So what Emily and I are doing tonight with you all, in what is deemed a quote unquote riot. So if you all go from this place and gather 5 or more people, 4 or more people, then is that a riot? Maybe, but if it is, then your organization or individual who helped organize that can be charged with a second-degree felony punishable by up to 8 years in prison and a $15,000 fine. So some examples: individual provides training on how to do peaceful civil disobedience to a group who plans to block a street or do a sit-in at a school. That individual could be charged with a second-degree felony. Or an individual loans his personal sound system for a demonstration that includes blocking a street. That individual could be charged with a second-degree felony. Or if the chairs of the Ohio Poor People's Campaign organize a sit-in at the State House, each of them could be charged with a second-degree felony. So again, just more ridiculousness taking place, and things that, example 2, the fact that because someone loans you their karaoke system so that you can use it to carry on a protest, and then the dude who loaned you the karaoke system is now on the hook, potentially. So the third provision expands to organizations providing active support or resources to a demonstration or protest connected with loss of property or harm to a police officer will be liable for triple the damages that are caused to that individual. So this would allow for civil suits. So not criminal penalties, but civil suits brought by first responders who feel attacked and harmed. Pardon me. So first example here, OFUPAC. OFUPAC organizes a peaceful demonstration against police brutality. And that demonstration devolves as several people break off who are not directly related with OFUPAC and cause damage, including to police officers' vehicles. Well, then OFUPAC could be liable for up to triple the damages to repair or replace those vehicles. Or UU Justice Ohio agrees to be a co-sponsor for a demonstration against racial violence in Columbus, which we urge their members to attend, which is something UUJO has done all throughout its history. And a police officer is injured by an unaffiliated person who attended that demonstration. Then UUJO could be liable for triple the damages for the officer's medical costs. And I can tell you that as tiny as UJO is, that would end us. So there are lots of folks this would silence if made law. Number 4, it creates a new offense of quote unquote riot assault, which makes it between a 3rd to 5th degree felony to engage in a riot and recklessly cause physical harm to another person. So again, in the new section of the law, creates this felony to recklessly cause physical harm to another person if engaged in a riot, which is now termed riot assault. But if the person harmed is a police officer, it rises to a 4th or 3rd degree felony. And reckless here in Ohio law is when with heedless indifference to the consequences, the person disregards a substantial and unjustifiable risk that such circumstances are likely to exist. And reckless is in contrast to knowingly, which is when a person is aware that another person's conduct will probably cause a result or will probably be of a certain nature. So those are important distinctions to understand. But also because of the vague language in this bill, it's like who decides what's reckless, what's willful, what's knowing, and that's one of the dangers of that. What is a riot? That's one of the issues with this bill, many issues with this bill. So the 5th provision, number 5, so we had riot assault. Well, now we've got a new offense called riot vandalism, which would make it between a 3rd and 5th degree felony to engage in a riot and recklessly cause physical harm to various kinds of property. So that would include of a person's profession, business, trade, or occupation where the damage is over $1,000. Property that is owned or controlled by a public entity. So for example, a city hall, school building, library, state house, a tomb, a monument, gravestone, or other similar structure. And this can increase to a 4th or 3rd degree felony as the value of the property harmed increases. So a couple of examples here would be if we use the Black Lives Matter protests as an example, where the organization's already liable for triple damages to public property. Under the above 2 sections, the leaders could also be charged with riot, vandalism, and assault. And the fact that the intention of the protest to be peaceful, and that it was a peaceful protest until a few people broke off at the end and did some damage, doesn't matter under the wording of this legislation. So under the current statutes, if the leaders of that action never knowingly intended for the property damage or any harm to happen, they wouldn't have any sort of liability because they didn't intend for that to happen. But under HB 109, it could be contended, and it's the could be's that I think make this so dangerous. It could be contended that there was violence and vandalism even in other parts of the country, and by organizing a protest here, that it could be, well, you would have known this was going to happen because it happened in XYZ other city and other places. A second example would be at a protest, a person takes a spray paint can and paints the word justice on the side of a school or a city hall building. That person could be charged with a 5th degree felony with penalties of up to 1 year in prison and a $2,500 fine. So again, more penalties heightened, new offenses created, this nebulous wording around so many things, which really, again, I will say, personally, I will say this as Pastor Hank, is really a dog whistle to say, we know only certain people are the ones who would riot and other people wouldn't riot. That's just a protest. And it's unfortunate that things got broken. But with some people, it's going to become a riot where things will get broken, and that's going to be a problem. So I think that that's also important to note as we move into talking about testimony, ideas for writing your testimony, and how to talk to folks about this bill. So I'm going to turn it back over to Emily to talk about the current status of HB 109.
Okay, so it's a lot to unpack, but Pastor Hank, you did a great job. So where we are now, as we mentioned up front, the bill has passed through the House. It was marginally amended, and now it's in the Senate Judiciary Committee. So in the Senate Judiciary Committee, they've heard sponsor testimony as we went through on April 5th. If the bill moves forward, the next step would be proponent testimony. So that's by people who support House Bill 109. After that is likely opponent testimony by people who oppose House Bill 109. This is my note. That's us. May not be everyone on this call. I would assume it probably is. And then after that, if there is, it would be interested party, and then they would have committee deliberations. They could make some revisions or amendments, and then they would have a vote. And if it's passed through committee, then it moves to the full Senate floor for a vote. If it passes the Senate floor, it would then go to the governor's office. So what we like to say is that we need to be vigilant and stay ready. Things could pick up and move quickly at any time. What we are hearing from our contacts is that right now, it's not anticipated to move for a while, but that could change depending on any protests over the summer, for example, or other activities. And that could really change, as Pastor Hanks likes to tell me, and ruin our Christmas, because that's during lame duck. And so that period is after the November election, but before the new folks take office. Sometimes that seems to be a crunch time to pass a bunch of horrible stuff like this. And so what we are doing is, after this policy hour, we're also going to be doing together a testimony training and walking through how can you testify if you're so called. What are the options? Most people don't know that you can actually submit written testimony, even if you're not able to testify in person. What are some best practices for testimony? And then kind of workshop a little bit if folks have questions. So I'll throw the link in the chat here once we stop screen sharing for anyone interested in being on the list to be notified about that. But if you were on the email list for this, you're probably already on the list for that too, but just in case. And then if you feel so inclined and want to get active on social media, I like to say that social media is not activism, but it is good for activating, and it is good for mobilizing. So we did do a Twitter 101 training together about a month or two ago, maybe 2 months. And we've got that on YouTube. And so in the follow-up emails from Pastor Hank and I will include the links for that. If anyone is curious about Twitter and or new, we've got really, really basics walking through how to do it. And so Twitter's kind of interesting. It provides opportunities for you to start some digital conversations in whatever your circles are online. But we would also encourage folks to have those in-person conversations in your circles or via email. And we're happy to help facilitate some of that if you feel like you need talking points, and we'll share our copies of the slides. If you're like, hey, just go listen to this video and you'll hear how horrible it is. We are happy to help because we know that it's going to take all of us to try and stop this thing. So I'm going to go ahead and close it out with our thank you here and stop the recording. But you've got our email addresses right here for Pastor Hank and myself. Contact either of us at any time with questions. I'm going to stop the recording so that folks can feel comfortable asking any questions. There is no bad question.